Thank you, Mr Speaker. I rise with some pleasure to talk with the Limitation Bill. This is an important piece of legislation which updates the former limitation, or the current Limitation Act 1950, which is obvious from its title, is already 60 years old. Can I thank the Attorney-General for his careful consideration of the issues in this bill, in particular in relation to gradual process injuries, which is an issue I want to come back to. The Limitation Bill is an important piece of legislation because what it tries to do is balance two interests. And on the one hand, we've got the interest, or the public interest, in enabling people who have been wronged to pursue through the courts a remedy to compensate them for the wrong that has been done for them. And we want them to have that right and not to take it off them unduly. On the other hand, we've got an interest in ensuring that the quality of justice is good by making sure that these disputes are resolved in a timely manner before people forget, before witnesses die, before documents are lost, because those things are important to making a good decision. We also have the important public interest in making sure that the sword of Damocles doesn't hang over the person who did the wrong forever. People should be able to move on with their lives after a reasonable period of time if the claim that is hanging over them is not pursued. And so the general rule is that people have 6 years to take their claim, and if they don't take their claim within 6 years, they lose their rights. And that 6-year period currently runs from when the cause of action arises. And what that means precisely is complex, and I haven't got time to go into it. That test has changed slightly in this Act, but in changing that test, we also introduce a more clear exceptions policy, because there are occasions where that normal 6-year rule would be unfair because people, through no fault of their own, don't know enough of the facts to ascertain that a wrong has been done to them or to know who they should sue. And so we have an exception where there is a lack of knowledge on the part of the injured person which would prevent them from bringing their claim within that 6-year period. So the general rule has an exception that can extend that period up until a longer period, but that longer period is in itself limited by what we call a long stop liability stop, or a long stop date, beyond which, no matter what your rights may have been, you've lost them because too much time's elapsed. And that's how we balance the interest, these two interests. Now, there are a couple of exceptions to that. An important one, exception to the normal 6-year rule, is in respect of minors who have been sexually abused. Obviously, they could be abused at age 3 and still be under the care and control of the person that abused them until they leave home 12 years later. So if we had a 6-year limitation period that applied in that case, it would be in causing the injustice to the child who was abused in their home and who would have no effective remedy. So that's one of the public policy reasons why we have an exception in respect of sexually abused children, and that is in the old Limitation Act, and that's carried forward into this legislation, and that's a good thing. There's another exception which we in the Labour Party were worried about, and that relates to gradual process injuries. Someone might be exposed to asbestos in the workplace. They might not know that they have been exposed to asbestos in the workplace until they develop asbestosis a number of years later. If there was a 6-year limitation period, that could happen after the 6 years. If there was a 15-year long stop period, it could even happen after 15 years, and so they would be without a remedy. Now, the bill came to the Select Committee without there being an exception in respect of gradual process injuries. And one of the justifications for that was if it was a work-related injury, or even if it wasn't work-related, but it was an accident, they would have cover under the Accident Compensation Scheme. But when we reflected on that at Select Committee, or when Labour members reflected on that at Select Committee, we realised that, who's to know what future accident compensation rules will be? Who's to know whether some of these things will or will not be outside the cover of the Accident Compensation Scheme? And it was notable to us when we look back at the old 1950 rules, the 1950 Act was not amended by the ACC Act. it sat alongside it. So if you had cover under the ACC Act and it said you had no rights outside of the ACC Act, well, that was covered in the ACC Act, not in the Limitation Act. So it became clear to us that we needed to, from a principle point of view, do in New Zealand what they do in Canada, which was one of the comparisons that was made. We actually needed to have an exception in respect of process injuries, and if those process injuries were long-term and they were covered by ACC, well, ACC takes care of that and no one's got any other risks, so that's settled under ACC legislation. But if they didn't have cover under ACC, then they ought not to lose their rights because of the provisions in the new limitation bill. We took that to the Attorney-General, and the Attorney-General looked at it, and can I thank the Attorney-General because I thought he shows wisdom in being an open-mindedness and being willing to look at that and then agreeing to that as an exception. There's one other issue that I want to deal with, because although we will be backing this bill, because it is a good bill, there's one issue that I do disagree with the government on, and that is in respect of having a different long-stop liability period for non-building claims to that which we have for building claims. We're saying that we're going to have a long-stop liability period for, other than some of those rare exceptions relating to sexual abuse of minors and gradual process injuries, the general point is that we have a long-stop liability period of 15 years. So after that 15 years, even if you didn't have knowledge to bring your claim earlier, you lose all of your rights. And then we're saying in respect of building cases, look, I'm sorry, you're not going to get the same long-stop liability period of 15 years, you're only going to get 10 years. First point I would make is this is irrelevant to the leaky building issues in Auckland, because the limitation bill that we are considering applies only to causes of action that arise from the date it is passed. So it doesn't apply to those leaky buildings that we already have in Auckland. So this difference between the 10-year and 15-year period in respect of building cases is irrelevant to the problems that we already have in Auckland and elsewhere with leaky buildings. But I see no difference in principle to a building claim, to a professional negligence claim, or to a claim where an agent of someone acting as my agent could fraudulently and without my knowledge defraud me of some of the money that was due to me from that agent to me, the principal. The principal, in that case, if there's an agent that's defrauding me, I've got 15 years to pursue my claim up to a 15-year long-stop period if there has been knowledge that wasn't reasonably knowledge that available to me reasonably that would enable me to bring my claim earlier. And yet we say, in respect of a building claim, that you're only going to have 10 years. And I don't understand the logical reason for the difference. Because there can be a failure in the foundations of a house that happens after 10 years that wasn't apparent. And so after that 10-year period, it's the problem of the building owner, because we've had this long-stop liability period click in at 10 years. Now, the justification that we were given at Select Committee was that building claims have complexity because they've got multiple parties. You know, you've got the architect, you've got the engineer, you've got the builder, you've got maybe the concrete layer or someone that put the steelwork into the foundations inappropriately. You've got multiple parties. So it is true that you do have multiple parties, and that. That might add a bit more complexity than would be the case in respect of a simple action between a principal and a single agent. But there are plenty of cases where there are complexity as to fact, and if you can't prove your case on the balance of probabilities in a case of complex fact, like a building case, in that period between 10 and 15 years, well, your case will fail. But I can't see the reason in principle why we are taking away or having a different long-stop liability period for people that suffer a failing building. This could be the loss of their most important asset in their life. The foundation could fail of their house and it could be largely worthless. The other issue that we said was that, well, we have fading memories in building cases. We have fading memories in all old cases, and I don't see a difference in principle there. And I'm not sure that it will be within the scope of this bill. It's something I will need to check with the Office of the Clerk. But assuming it is within the scope of this bill, I will be promoting at the committee stage of this bill an amendment to actually have the same long-stop liability period applying to Building Act cases as applies to all other cases, because I don't see the difference in principle. You can argue that they should all be 10 years, that Building Act cases should be a 10-year long stop period and that other ones should, but they should be consistent. They should all either be at 10 years or all